Bob Lambert's AssetProtectionTraining.com presents Ryan Fowler on the Homestead Exemption.
Hi, my name is Ryan Fowler and welcome to the AssetProtectionTraining.com video series. We're going to start out a four-part series about protecting your home, and this is part one. We're going to talk about homestead exemptions, what they are and to what extent they protect your home. So what is a homestead exemption? Well, it's provision of law that generally protects some or all of your home from private creditors. Now, homestead protection greatly varies between states. Some states offer unlimited homestead protection, meaning no matter what your home's worth, it's protected from private creditors. Some offer just some protection, some offer none at all or just a little. And there's an example on the PowerPoint of Arizona's homestead protection statute where they protect $150,000 in a home's equity from creditors. So if you have a $300,000 property in Arizona and someone forecloses on it, then $150,000 of your equity will be protected. But if there's more equity and they foreclose and they're able to get above and beyond $150,000 from the foreclosure sale, they'll get anything above that. So that's how homestead protection would work in Arizona, for example. So we need to talk about what homestead exemption is not and what does it not protect against. Well, generally speaking, there's a little bit of variation here, but generally speaking, homestead exemption does not protect against tax liens. It won't protect you in divorce. It won't protect you if you take out a loan against the home or you have pay someone to do repairs or improvements on the home. They can put a mechanics lien on it. And again, a home loan or mortgage, they can take your home. In bankruptcy, and this is a change in the law due to the 2005 Bankruptcy Abuse Prevention and Consumer Protection Act, if you own a home for 1,215 days or less, then even if your state has a greater homestead protection than $125,000, you're only going to be able to claim in bankruptcy Chapter 7 a maximum $125,000 homestead exemption. Now, if your state offers less homestead protection than that, then you'll most likely have less than the $125,000. It'll be the lesser state exemption, whatever that is. If you own your home longer than 1,215 days, and let's say you're in Florida, which has unlimited homestead exemption, that's about 3.5 years. So as long as you own it that period of time and then you declare bankruptcy, you're going to get the full exemption allowed by the state. That $125,000 cap is removed. How do homestead exemptions fare in a fraudulent transfer context? Just so you know, fraudulent transfer is if you transfer an asset specifically to defeat, delay, or hinder a creditor with that intent, and that's a fraudulent transfer, and a judge can undo your transfer and put the asset back in your name or change from an exempt asset to your old asset that wasn't exempt so that the creditor can grab it. Now, in some states, most notably Florida, even if you purchase a big home and it's exempt so the creditor can't get it, and your old asset was a big trading account, let's say you had a $2 million trading account and you cash it out and buy a $2 million home because you just got a judgment against you. In a state like Florida, there's actually a court case that says, well, even if you did that to evade a creditor cannot do anything about it. You're going to keep the home. The court's line of reasoning was because the homestead exemption is part of the Florida Constitution, so they can't write a regular statute law, which is a lesser law, to overrule the Constitution. Now, other states have homestead exemption as part of their Constitution, for example, Texas. So it may be possible that the same outcome will happen with a court case in Texas, but it hasn't been decided yet. Now, other states, actually, majority of states, their homestead protection in their laws, the homestead exemption, is a matter of just the normal law and not part of the Constitution. Now, a lot of judges will be hesitant to take your home away from you that would otherwise be protected by statute as a result of you did it to evade or defeat a creditor, but not guaranteed by any means. So if it's just a normal statute law, not part of the Constitution, don't count on the homestead exemption protecting you. If you buy a huge house that's completely shielded by the homestead law, because you just got a judgment against you or you just got sued. Anytime you do something after creditor threat materializes, you do have a chance, except in Florida and the other exceptions, you do have a chance of a fraudulent transfer ruling coming back to haunt you, and you lose your protection and undoes what you did. So now we're just going to really quickly go over the homestead exemption in each and every state. So Alabama is 5,000 single person, 10,000 for a married couple. Here's the statutes here. I'm not going to read over those. Alaska, $67,500. Arizona, $150,000. Arkansas is unlimited for married or head of household. California, $50,000 if you're single, $75,000 head of household, or $150,000 if you're over 65 or disabled. Colorado is a $45,000 exemption. Connecticut, $75,000. Delaware, $50,000. Washington, D.C. is unlimited. You can get as big a home as you want. It's protected. Same thing in Florida, except it's 160 acres maximum in a rural area, half acre urban, but unlimited in value is protected. Georgia, $50,000 or $100,000 if you're married. Hawaii is $20,000 single, $30,000 if you're head of household over 65. Idaho, $100,000. Illinois, $15,000. Indiana is $15,000. Iowa is unlimited, 40 acres rural or half acre in an urban area. Kansas, unlimited, 160 acres or 1 acre in an urban area. Kentucky's $5,000. Louisiana, $25,000. Maine, $35,000 or $75,000 if you have minor dependents, children under 18 or other dependents under 18. Maryland, no homestead exemption. Frowny face there. Okay, Massachusetts, $500,000, but if you have a home with multiple owners and they're each age 62 or disabled, then you get $500,000 for each owner or resident that's disabled over that age. Michigan, $35,000 or $45,000 if you're over 65 or disabled. Minnesota, $750,000 in a rural area up to 160 acres in size. In an urban area, $300,000. Mississippi, $75,000 for 160 acre maximum size. Missouri, $15,000. Montana, $100,000. Nebraska, $12,500 if you're head of household. If you're not, then you have no exemption. I should put a frowny face there too. Nevada, $350,000. New Hampshire, $100,000. New Jersey, no homestead protection at all. New Mexico, $60,000. New York, $50,000. North Carolina, $18,500 or $37,500 if you're married. North Dakota, $80,000. Ohio, $5,000. Oklahoma, unlimited if you have up to 160 acres in rural area or up to 1 acre urban, but unlimited cash value. Oregon, $39,600. Pennsylvania, frowny face, no protection, no state protection. Rhode Island, $350,000. South Carolina, $50,000 per owner, up to $100,000 maximum. South Dakota, unlimited exemption for up to 160 acres in size rural or 1 acre in an urban area. Tennessee, $7,500 if you're single, $12,500 single over 62, $20,000 married and one spouse is over 62, $25,000 married and both spouses are over 62. Texas is unlimited up to 100 acres rural or 200 acres if you're family. That's and then up to 1 acre in an urban area. Utah, $20,000 if you're unmarried, $40,000 if you're married. Vermont, $75,000. Virginia, $5,000. Washington, $125,000. West Virginia, $25,000. Wisconsin, $40,000. And Wyoming, $20,000 homestead exemption. Now, as you noticed, a lot of these states don't have a huge homestead exemption. And if you have a home that has a lot of equity in it, a lot of these states are not going to completely protect your home. So in the next video, we're going to talk about the non-qualified personal residence trust, which is a great planning tool. And we're also going to talk about equity stripping in part 3. And then in part 4, we're going to talk about co-ownership, such as tenants by the entirety, which can also be a cheap and sometimes effective way to protect your home by tenants by the entirety. And we'll discuss other types of co-ownership in Part 4, such as tenants by the tenants in common, joint tenants with right of survivorship, etc. So we'll see you in the next video.